Hello viewers, I am Professor Sharanjeet, working at the Rajiv Gandhi National University of Law, Punjab. Today we shall talk about the futuristic approach towards prison system. I'll start today's lecture with a famous quote. The best way to keep a prisoner from escaping is to make sure he never knows he is in a prison. So how do we make sure that a person doesn't feel like he is in prison? Dear viewers, this can be achieved by adopting a futuristic system to the correctional administration in the country. So we shall start with reduction of population of under trials in the prisons. Overcrowding in prisons leads to a plethora of problems. In the Law Commission of India's 277th report entitled Wrongful Prosecutions, Miscarriage of Justice, international studies have also been quoted, according to which India ranks 16th highest in the world with regards to the under trial population, and it is the 5th highest among the Asian countries. Such a large population of under trials, which is in fact more than the number of convicts, is a financial burden on the state governments as well. In the case of Thana Singh versus Central Bureau of Narcotics, the Supreme Court made the observation that the laxity with which we throw citizens into prison reflects our lack of appreciation for the repercussions of incarceration. The callousness with which we leave them there reflects our lack of empathy for humanity. It also reflects our imprudence when our prisons are bursting at the seams. The urgent need of the hour is to reduce the under trial population in the country. This will also help in reducing the other problems the prison administration is currently suffering. One method of decongesting prisons is by liberalizing the bail provisions. The Supreme Court has time and again emphasized that bail should be the rule and jail should be an exception. Under trial review committees should be constituted to continuously identify prisoners who could be released. The provisions of various special laws should not be misused to make arrests of innocent persons on account of personal vendetta. Plea bargaining should be explored to the maximum. The remission of the life sentence should also be focused on, irrespective of the economic background of the convict, because it is a sad reality that law grinds the poor and the rich rides on it. Next, we shall focus on overhaul of the criminal justice system in the country. Dear listeners, in continuation of the previous point, it is highly imperative that urgent reforms be brought into the criminal justice administration of our country. These reforms will also impact the prison administration. One such recent initiative of reform is the substantive criminal law in the Bharatiya Nyaya Sanhita 2023 with regards to the introduction of community service as a form of punishment. Similarly, making public servants liable for malicious arrests, investigation, or the application of wrongful procedures would serve as a deterrent and also help in preventing wrongful arrests and consequent overcrowding in the jails. It is often said that justice delayed is justice denied. A speedy trial can become an effective tool to address the overcrowding in the jails. Special fast-track courts need to be set up to exclusively deal with petty offences and cases pending for 5 years or more. It is also felt that the High Court should direct the district and sessions judges who regularly monitor the progress of cases pending in courts where the accused is in custody for more than a year in a session tribal case and for more than 6 months in a magistrate tribal case. The regular bail provisions remain pending, arbitrary arrests are alleged to be made, the judge to population ratio is very low, there are prolonged trials, and the absence of legal aid are some factors that needs to be seriously considered. More reliance should be placed on the Probation of Offenders Act 1958 and other alternative forms of imprisonment such as community service, forfeiture of property, payment of compensation to the victims, and imposition of a heavy fine in place of incarceration. Next requirement is the strengthening of the open prison culture. Open prisons help in the complete transformation of the wrongdoer by catering to their psychological, emotional, physical, and economic well-being. They help inculcate a spirit of self-discipline among the inmates. As most of the inmates are occupied with gainful employment opportunities, the recidivism rates are also considerably reduced. In the Indian context, it is recommended that more open prisons be set up in each state of the country. Architectural reform is another aspect with regards to prison administration. In January 2024, the Supreme Court of India ordered the state governments to establish district committees to assess the available infrastructure in jails and take a decision on the number of additional prisons to be constructed. While constructing new prisons, it is imperative to take note of modern requirements and considerations like separate provision for under trials and convict prisoners and special facilities for transgender prisoners with regards to sanitation. The old jails in cities are mostly single-storied. These can be converted into multi-storied ones. Another crucial aspect is economic rehabilitation of the prisoners. The convict prisoner should be provided with vocational training, skill development courses, and educational facilities within the prison. The aftercare program should also include helping the prisoner find a job, procuring a bank loan for the purpose of a small cottage industry, or setting up a business. The women jails must collaborate with handloom and other small-scale industries, which will provide an opportunity for female inmates to improve their skills, which will also lead to the effective implementation of the reformative theory of justice. As per retired IPS officer Kiran Bedi, who won the Ramon Magsaysay Award in 1994 for her reform measures at the Tihar jail, prisoners with professional skills, whether under trial or convicted, must be identified to train others. We can build on time with prisoners and create an ecosystem where the prisons can become rehabilitation and skilling centers. When a prisoner enters the system, his profile details of skills and employment must be created and shared across the different jails of the country. The skills of the inmates must be marketed so that the work orders can be accepted from anywhere. More emphasis should be given on women prisoners with children. The urgent need of the hour is to reduce gender disparities among the prisoners in matters of medical care, legal aid, and rehabilitation facilities. Requisite provisions should be made for sanitary napkins inside the prisons for the benefit of the female inmates. All the Indian states are not providing adequate facilities for the children of the female prisoners. The under trial and convicted female prisoners are also lodged together. Many Indian prisons lack medical and psychiatric care for the females in the jails. The urgent need of the hour is to introduce telemedicine facilities for remote diagnosis and virtual consultation with the female prisoners. Another sensitive aspect is with regards to suicide prevention in the jails. The state authority is responsible for protecting the health and safety of the inmates, and continuing suicide constitutes a gross violation of human rights. Thus, suicide prevention is very important. Suicide prevention can be achieved by filling up the vacancies, documenting the staff strength, and training prison staff with a component of mental health literacy. The prison staff should also be trained to administer psychological first aid. Psychological first aid is a training program to identify, understand, and respond to signs of mental illness and substance abuse disorders, to enable the trainees to develop the skills to reach out and provide the necessary support to an inmate developing a mental health problem. Furthermore, mental health screening should be included in the initial health screening report of every prisoner. If the preliminary screening identifies signs and symptoms of a mental health disorder, a mental health professional should be consulted. Then, there is also a need for supervision and monitoring of such prisoners. There should be assessment, treatment, and observation of all the inmates. Suspectable prisoners should not be employed in work that involves the use of sharp or heavy instruments. Telephone contact with friends or family members of the prisoner should be ensured at regular intervals as per the relevant rules and regulations of the prison. An adequate number of telephones should be installed in the prisons, considering the number of prisoners. The high-risk prisoners should also be shifted to premises that enable 24/7 monitoring with the help of CCTV cameras. It is to be ensured that fellow prisoners do not disturb prisoners with mental health issues. Programs on mental health should be organized regularly to sensitize the prisoners. The prison administration should collaborate with local mental health care institutions in this regard. The prison housekeeping staff should ensure that abrasive chemicals are beyond the reach of the prisoners. Tools used for maintenance, such as ropes, glass, wooden ladders, and pipes, should be kept in the safe custody of the concerned prison staff. Since most suicides take place in prison toilets, there should be no iron rod, ventilation grill, fan, or hook in the toilet that can be used for hanging. Next, we shall focus on more emphasis on the aftercare of the prisoners. Aftercare has the ability to complete the circle of reformation and rehabilitation of the offender in the society. The primary focus of the aftercare program is to ensure that the prisoner, after his release, has fully integrated and rehabilitated himself or herself in the society as an honest and law-abiding person. Aftercare with regards to a prisoner would involve helping him to procure a decent job, a loan, or any other help in setting up a small or a cottage industry. In India, aftercare needs to be implemented forcefully. A robust aftercare program would help in achieving the objective of correctional administration in a much better way. Next, we shall discuss the active role of the society. There is a need to coordinate with different segments of the society like educational institutions, the industrial and corporate sectors, the agricultural sector, and the healthcare sector, so as to promote the skill development of the inmates or make use of the skills if they are already present. Even the NGOs can be given a bigger role to play in the rehabilitation of the inmates. Next crucial aspect is with regards to reducing recidivism. Relapsing into crime is a serious problem. When a criminal relapses into crime, he or she again increases the burden on the already burdened jails. The urgent need of the hour is to utilize all available resources in order to reform the prisoners in the best possible way so that recidivism can be eliminated. Strong emphasis should be given to the reintegration of the offender. Social reintegration will enhance public safety. The stigma associated with incarceration should be wiped out completely, and society needs to do a little hand-holding for the released convict. Now we shall discuss the aspect of improving the working conditions of the prison management staff. Most of the Indian jails suffer from a shortage of prison staff, whereas the inmate population is greater than the prison capacity. The urgent need of the hour is to increase the staff strength. The staff should also be given adequate remuneration. The government should ensure their proper training and promotions in order to boost their morale. Increased discipline among the inmates should also be focused on, as at times the inmates are found to misbehave with the correctional staff. Adequate provisions for staff quarters should also be made. A sufficient number of female warders and jailers should be recruited in all the states because there is a shortage of female prison staff across the country. Filling up of vacant vacancies in the prison department would also reduce the workload of the existing staff, which in turn helps in the better management of the prisons. The staff-inmate ratio does not adhere to the benchmark stipulated by the Model Prison Manual of 2016. Dear listeners, there is also a need for more reliance on restorative justice. Restorative justice works on the principle that the objective behind the criminal law is not merely to punish the offender, and instead of the offender being simply tried and punished, the system should focus on the victim as well by placing emphasis on restoring the victim to the same position as he or she was before the occurrence of the crime. Restorative justice allows inputs from the victim, the community members, and the offender to repair the harm caused by the offender. In the Indian context, in the case of Karan versus NCT of Delhi, the court dealt with the concept of the victim impact statement in tune with the concept of restorative justice. Restorative justice works on the principle of promoting the healing of all the affected parties and giving the offender the opportunity to make the necessary amends. Thus, by relying on restorative justice and looking for alternatives to punishment, the prison population can be considerably reduced. Next is normalizing life behind the bars. Normalizing life inside the prison can be achieved by placing emphasis on the reintegration and rehabilitation of the offender. Through the digital medium, constant contact with the family members of the inmate can be maintained. This helps preserve the family ties of the inmate and also keeps him socially active. Globally, it is felt that cognitive behavioral therapy also helps in reducing recidivism among the adult offenders. This therapy assumes that most people can become conscious of their own behaviors and then try to make positive changes in themselves. Normalization can also be achieved if the prisoners have access to the same basic facilities inside the prison as they had outside the prisons. But if the prisoners are merely lodged in the prison setup, normalization can never be achieved. Next, we shall focus on reducing poverty, illiteracy, and marginalization. Dear viewers, there is no denying the fact that poverty may increase the possibility of criminal activities among the people. Lack of education, employment, and economic opportunities may force a person to treat the path of criminality for subsistence. Reducing poverty and illiteracy will reduce the crime rate, and this will again help in reducing the population of prison inmates in the country. Another aspect is with regards to the prisoners who are lodged in the jails and are illiterate and marginalized. They are not aware of their legal rights. Volunteers from diverse legal backgrounds can be roped in to provide basic legal knowledge to such inmates. Improving the health facilities inside the prisons is also very imperative. A healthy mind lives in a healthy body. The reformation of the prisoners cannot be achieved until and unless they are given proper living conditions and health facilities within the four walls of a jail. Furthermore, the right to health is an important aspect of the fundamental right to life. Due to the specific conditions inside the jail, the inmate suffers from both physical and mental health related problems like depression, sleeplessness, post-traumatic stress disorder, hepatitis, HIV/AIDS, and tuberculosis. Communicable diseases are widespread due to overcrowding and congestion in the prisons. In 2023, the Delhi High Court formed a committee to improve the healthcare facilities in prisons by emphasizing that every inmate has an inherent right to humane treatment. There is an urgent need to have adequate medical infrastructure in prisons and adequate arrangements to deal with emergency health problems like a cardiac arrest or a hemorrhage. It is important to refer to the case of Rasik Bhai, Ram Singh Rana and others versus State of Gujarat, which was heard by the Gujarat High Court on 31st March 1997. The case involved life prisoners with serious illness who requested temporary bail to receive emergency medical treatment from private doctors. One of the petitioners had serious eye problems. The Gujarat High Court ordered the government to pay 1 lakh in compensation to the convict for his illegal incarceration in the jail for almost 3 years. Similarly, in the landmark case of Parmanand Katara versus Union of India, the Supreme Court held that the state has a duty to maintain life regardless of whether the individual is innocent or guilty of a crime, setting up a strong precedent for prisoners' rights in India, particularly the fundamental right to health guaranteed by Article 21 of the Constitution. Particular emphasis should also be given to the health of the elderly prisoners. Moving forward, there is again a substantial requirement for sufficient provisions for the transgender inmates. India has enacted the Transgender Persons Protection of Rights Act 2019 to provide for the protection of the rights of the transgender persons and their welfare. As per this law, a transgender person means a person whose gender does not match the gender assigned to that person at birth and includes trans men or trans women, people with intersex variations, gender queers, and persons having such social, cultural, or identities such as Kinnar, Hijra, or Aravani. The Supreme Court's Committee on Prison Reforms has also recommended that transgender people be treated equally and given the same rights and facilities as other inmates. In this committee headed by Justice Amitwa Roy, it has been recommended that jail staff and correctional administration at all levels, particularly the guarding personnel, be given adequate and regular training in order to equip them to appropriately interact with the transgender persons. The committee further observed that it is essential to observe that any and all attempts to separate transgender prisoners from other prisoners for security and safety reasons must not result in their isolation. As per Section 11 of the Transgender Persons Protection of Rights Act 2019, the prison authorities are also required to designate a complaint officer to deal with complaints of violations of the rights of the transgender inmates in the prisons. Unfortunately, the majority of the states and union territories have not formulated welfare schemes for the transgender people. There is an urgent need to ensure that jails have adequate sanitation facilities with separate baths and toilets exclusively for transgender people in order to avoid their physical abuse and harassment. Furthermore, a comprehensive health checkup followed by a social and psychological evaluation should be conducted for every transgender prisoner at the time of their admission in the prison. The transgender convicts should also be encouraged to participate in various forms of recreational, skill building and vocational training in the prisons without discriminating on the basis of their gender. With this, we come to the end of today's lecture. Thank you very much.